Good morning, everyone, and welcome to this night breakfast briefing at KLC with me, Kaz Carrington. And this morning, we're going to be talking about people being absent without leave, or AWOL, as we call it. So 30 minutes will be done and dusted. Just a few things before we start. If you have any questions, if you've been on one of these before, you'll know that you can type your questions in the chat box, and my colleague Melanie Whittle will answer them for you. If you don't get your question answered, or if you've got a more complex question about today's topics, then you can email into us, no problem at all, and we'll get back to you with a response. On technical support again today is Liv Harris from GoHo. So thanks very much both to Melanie and to Liv for that. Right, just a few more things before we start. I just wanted to make you aware that we've opened the bookings for our Law on Tour this morning. And this is the autumn tour. We run tours in the spring and the autumn at venues around the UK. It's one-day employment law seminar. Some of you may have already come on it before, but we deal with a range of topics, very topical matters, obviously, case law, what's new in employment law, but we also pick things that are typically problematic for HR folk. So have a look at that. There's discounts available. If you are interested, you want to know more, pop on our website. That's klcemploymentlaw.com. Go on to the page that says Law on Tour, and you'll see what the tour is all about, and there's the opportunity to book. And if you don't want to book through that booking system, you can just call us and we can get you booked on and invoice in that way. So that's the best thing to do. Okay, on to our topic then. AWOL, absence without leave. So this is what we're going to be covering. So first of all, what it means, when people can go AWOL, what we do, what steps we should take initially. And I'm very keen to be clear that what you don't want to do is just think, oh, we'll leave a couple of days and something will resolve, because that's the worst thing you can do. We'll have a discussion about your absence reporting procedures. If you've got one, hopefully you have, the importance of adhering to it, why people actually do go absent without leave, how we manage that, and a fair process and a fair dismissal, because in a lot of these cases, I have to say, and you'll probably be aware, that if somebody does go AWOL, it generally means that they don't come back, and it generally means that we have to dismiss them. And what we want to make sure we do a fair dismissal, not do something which seems fair at the time because we're indignant that how dare they go off and not tell us. And it's, of course, it would be fair just to dismiss them. Many times it isn't, and we have to make sure we dot our I's and cross our T's, and then we can breathe a sigh of relief and move on. Okay, then, so where does this term come from? AWOL, absent without leave. It's actually a military term. I think it's first coined in World War I. So somebody absent from their post or their duty without permission. And obviously in the military, if you are caught absent from your post, then that could end in a court-martial, which back in World War I days could mean that you were up in front of a firing squad. So hopefully that's not going to be the outcome for your employees, but that's where the term comes from. So AWOL, absent without leave. So first steps, somebody doesn't turn up for work, and let's talk about them being physically present in the workplace first of all. What happens? Well, hopefully their manager will notice that they're not there, or their supervisor or somebody will notice that they're not there. And I'm assuming, because I think this is what most of us would feel like, is your first reaction if you know somebody pretty well is concern. Where is this person? Where have they gone? Why are they not in? Perhaps it's the trains, and perhaps it's a problem with the car, or perhaps it's something else. Now, I would suggest that if you know somebody very well, and you know that if they were to be late or not come in, that they would let you know, they're very reliable normally, that you might move straight to want to contact their emergency contact. Now, clearly, if you don't know somebody so well, it might be that you delay that a little bit. But I would suggest that it would depend on how well you know the individual and how well you know the way they normally behave. So use your judgment with this. If somebody is working remotely, so you might have people who are working from home all the time, or they might be working sort of a hybrid working pattern. So who notices if they're not at work? What's the procedure that they have and you have for them effectively reporting in? Just concerns here in terms of welfare, because if that person lives alone and something has happened to them, how long would it take for somebody to know? Some work systems require employees to log in. You can't start working until you log in, and when somebody logs in, you know clearly that they're okay. But if you haven't got that sort of system, how do you ensure that people are okay? And I'm thinking this from a welfare point of view, not a we're going to, discipline somebody point of view. Perhaps you can have some system whereby there is a mechanism for doing this without them feeling that BB is Big Brother, not breakfast briefing. Big Brother is not watching them. So some way of knowing this. Now, the reason that I'm going on a little bit about welfare is that many years ago, I had a colleague who, she was disabled. She had some physical mobility challenges, and she lived on her own. And she was very, very reliable and was never off work. She was never sick. And one day she didn't come in. And her closer colleagues were very concerned about this, and they wanted to go and check out that she was okay. It seemed a little bit over the top, might be to you, but they literally, after an hour that she hadn't come to work, they went round to her home, knocked on the door, no answer, looked through the letterbox, and they saw her lying at the bottom of her stairs. Now, I think that stuck with me. If they had left it longer, a couple of days, who knows what would have happened. So if you have concerns, act on them. Always remember that your overarching duty of care and obviously your compassion for people really overrides any other issues that they might have with you, that you're being a bit overbearing. So always bear that in mind, but use your judgments in this. So what could happen? Sometimes people, first of all, advise you that they're poorly. They might ring up and say, I'm not going to be in today, I'm not very well. But then you don't get anything else. You don't have any further contact with them. You don't have any more medical information about them. And when you ask for information, have they been to the doctors? Have they seen a doctor, etc.? You don't get anything back. Now, you can't compel somebody to consent to go and see their GP or your occupational health, but you can tell them that they don't respond to your very reasonable inquiries about where they are, that this might mean that you would start the disciplinary process. Certainly, you would suspend pay. And I'm talking about suspension. It's always a good word to use, because if you have made a mistake and the poor person is, tied up somewhere, been taken hostage, you don't want to look silly and look like, we stop their pay immediately. But suspension of pay, which means you would stop pay, but you call it suspension, which means that you might reinstate pay at a later point. Now, if people do not contact you, even when they've gone off sick, and you can't get any communication, that will generally be considered to be gross misconduct. And if you dismiss, we'll be dismissing for gross misconduct. So what if they turn up after being AWOL for a considerable period of time or a few days? What do we do? Do we just slam into a disciplinary procedure? Well, obviously we investigate why they were absent and why they didn't contact us. So sometimes there will be very plausible reasons. Some things happen. You're coming back on a ferry and the ferry got cut off and there was no telephone signal, etc. I mean, there might be reasons why people can't contact you. So it's always good to explore that first. But there may be possible disciplinary consequences. Clearly, if you're happy with their explanation, then you would reinstate the pay for the relevant period that you have suspended it for. But if it's something you're given a reason and you're thinking, okay, it's kind of plausible, but I mean, there might be a workaround in terms of, okay, that happened. In the future, can you do X, Y, Z? So there might be a way of encouraging people maybe to, take further steps in the future rather than just sort of think, oh, well, it's okay, I don't actually have to because I've got a good excuse. Maybe, well, actually, if I tell somebody else to use their phone, then they might get through and my employer might know that I'm not coming into work. So it's kind of that approach for these type of situations. If they eventually send in a medical evidence covering their absence and they're still not coming back, again, investigate why it took so long for them to send in information to us. And again, if you're satisfied, advise that that's okay, pay be reinstated. But again, further failure to adhere to absence reporting procedures may result in disciplinary action. I think it's very important to be clear that your absence reporting procedures are there for a reason. They're there to make sure that you can meet your commitments in terms of sick pay, but they're also there to make sure that you are in control, if you like, of the welfare of that person. You know that that person is safe and well. Absence reporting procedures then, I'm sure you have one. If you have, stick to it. If you haven't got one, then get one. You really should. And in that procedure, don't be woolly. Don't just say you must ring us. Who must they ring? When must they ring? Or how must they communicate? So if you want them to actually call, say that, and say if you can't get through, then you may email or text, but be very clear about that. And do not let that go. Do not be lax about it. Because once you start letting people, oh, I know I meant to ring in within an hour, but I didn't, so I rang in the midday. Or I know I meant to speak to my supervisor, but I sent my colleague a text to tell that person to tell the supervisor. Once you start allowing that and accepting that, that becomes the norm, and you will find it very difficult to pull back from that position. So be strict about it from the get-go. Say to people, look, it's important you stick to us. Failure to do this will mean that you may not get pay, and it may result also in disciplinary action in certain circumstances. So do be all over that. So reasons for them being absent without leave, myriad reasons. But like my ex-colleague, they might have had an accident. It might be something like that, which is why you might want to sort of move to, or do we need to contact somebody? Do we need to find out from their emergency contact? Clearly, if we sometimes refuse leave because sometimes operationally it's just not possible for us to allow people to take leave when they've asked, sometimes people would just take the leave anyway. Sometimes they'll say they're sick. Sometimes they'll just take the leave and almost, be defiant about it. If that happens, clearly we'll have to treat that one of two ways. If they just go off and don't tell us, then I think you treat that as a disciplinary matter. That's not necessarily going to be a dismissing offence, but you're very clear. That is, you have sort of misunderstood my reasons why you can't go on leave, and you misunderstood me telling you that you weren't meant to go. Clearly, if it happens again, that will be serious consequences, and you may even go to a final warning with that. If somebody puts in a sick note, well, you can say on one hand, oh, well, that means they were sick, I can't prove they weren't. You don't have to prove that they weren't, remember. It's just a genuine belief on reasonable grounds that they may have actually been telling a porcupine. So you may decide to take action because effectively, if they have just disobeyed and just sort of decided to, well, I'll just go sick anyway, that is being absent without your leave to be absent. So you can make a decision on how you would treat that. Some people overstay their holiday, their leave. So this happens quite a lot when people are maybe returning home where relatives are, and sometimes they overstay their leave, and there's all sorts of reasons why they can't come back. And I think it's important that you are clear in your policy, your leave policy, and if you have an AWOL policy or AWOL policy, what is acceptable and what isn't. And I think it's very important to be clear that, just oh well, oh I got confused over the tickets, or I had to stay because of this particular reason. There's going to have to be compelling reasons for you to find it acceptable for somebody to overstay their leave by lengthy periods. Now, clearly there'll be opportunities and times where you will be happy with somebody's reasons for overstaying their leave, but again, be clear about that in your policy. One of the most common aspects of AWOL is that people just go off and you don't know where they are, they don't contact you, you can't contact them. And the way you find out they are actually still living on planet Earth is that somebody will say, oh, Fred, he used to work in dispatch, he's working for Blogs Limited down the road. So you find out from somebody else. Okay, so let's move into managing people who go AWOL, having our AWOL policy. Secondly, be sure that you have a clause in your contract which allows you to stop pay for unauthorized absence. Because if you haven't and you want to stop their pay, you might call it suspension, but we're going to stop the pay and might reinstate. If you do that without that relevant clause, then that might be an unauthorized deduction from their pay. And if push comes to shove and we end up in tribunal, we might have to actually give them that money even though they did not work those days. So really be sure that you can stop pay. So you just say for an unauthorized absence, we may stop, the relevant number of days pay. So be proactive in this. Don't let matters slip. If your initial concerns and inquiries about the individual come to nothing, then we must move to a process, a procedure, and this is what we would suggest. So day one, you try to make your contacts, don't you, by phone, text, email, carrier pigeon, whatever it is, advising that you're concerned about the individual. And do you remember I said in certain circumstances, emergency contacts might be, the next phase, because if you know somebody very well and they're very reliable and they haven't rocked up to work and you have concerns, then that might be what you do. Remember, your overarching duty of care, for me, trumps really anything else. Day two, if you haven't heard anything, try to make contact again. And if you can't make contact by phone or text, etc., then you need to write to them and remind them of your absence reporting procedure. Remind them that they don't get paid if it's deemed to be unauthorized absence, and that it might lead to disciplinary action being taken against them, and send that recorded delivery and normal post as well. Now, day three, obviously, you've got to have a chance, wait for that person to receive the letter, but I would make my normal inquiries by text, by telephone, keep that going. On day four, I would repeat all those actions, but this time, if not successful, contact them again by letter, advising that while you're very concerned about their welfare, their absence is now being treated as unauthorized and pay has been stopped. And explain that they have to contact you by a certain time. Now, don't give it 2 weeks. There's no need for that. Be quite clear. You must contact us, within 2 days or by tomorrow, and explain that that if they don't contact, that's likely to lead to disciplinary action. Send it recorded and normal post as well. Then what? Deadline for contact. They don't meet it. Again, we repeat our actions about trying to contact them by phone, etc. But if we can't contact them, we write again, now explaining that their lack of contact is being treated as gross misconduct and they're required to attend a disciplinary hearing and advise of all their rights, so the right to be accompanied. Explain that if they don't attend the hearing may go ahead in their absence, and if they fail to attend and there's no explanation, that obviously that may result in their dismissal. Again, send recorded and normal delivery. Now, several outcomes here. If no contact is made on the disciplinary hearing day, or you don't know somebody's coming, you're there, ready and waiting, ready to rock and roll, again, try to call, text. If you are quite risk averse, and some organisations are, rearrange the hearing, write again, recorded delivery, advising them that they must attend. If you're less risk averse, and no contact is made, or they make contact but it's a sort of a pathetic excuse, then you might consider that you've got enough information, you're going to consider the matter in their absence, and confirm in writing and send recorded and normal delivery to them. So you would have heard that in their absence, you might have decided to dismiss them. Clearly, you would have considered all the circumstances, that there may not be any evidence at all that they've provided because they haven't contacted you at all, but you will consider things like the fact that, okay, how long they've been employed by us, all those sorts of things. Go through the normal process, and then you write your dismissal outcome letter, giving obviously the right to appeal. Now, continued unauthorised absence is a gross misconduct offence. That means that if we do decide to dismiss because they have gone AWOL, then that would be gross misconduct, and that means that there will be no notice payable or any pay in lieu of notice. Now, you might think, oh, it seems rather sledgehammer to crack a nut, because if somebody's just gone off, they've gone off. And some people say to us, oh, well, should we just, assume that the contract has been frustrated? No, because if you assume that, they might just decide to come into work, 2 weeks, 3 weeks, 4 weeks, 5 weeks time. There have been instances where people have been away, absent without leave for months, sometimes years, and then made contact. And if you haven't gone through the process of actually physically dismissing them through a fair process with a fair reason, then you can be in all sorts of difficulties. And organisations have been found to have unfairly dismissed people and to have unlawfully deducted money from their salary because they haven't gone through those rigorous processes. So it's really something which is sometimes seen as a bit of a pain, but it's not really too onerous. There are several steps, like the steps that I've talked about, that you go through, that you have to almost bite the bullet to do, but have that process and make sure you do it every time. And also make sure, as I mentioned, that you stick to your absence reporting procedures, that you make people adhere to them. If they haven't got a good reason for adhering to them, then you take the appropriate action, because that is the place where you start. If people think that they can just, oh, well, it doesn't really matter if I don't report in, then that's when things start to go really wrong. As I mentioned, most of the time, this will be a situation when people go absent without leave where you probably won't see them again, but sometimes they do come back in, and sometimes they do come back in with all sorts of weird and wonderful reasons why they haven't made contact. And that is why it is so important to have that clear and fair audit trail. Remember, when we're dismissing, we need that potentially fair reason. Well, we think we've got it with our gross misconduct, but we also need that fair process. And we need to make sure that we can serve Section 98(4) of the Employment Rights Act, which talks about in all the circumstances of the case, was it reasonable to dismiss, given, what we knew about the situation, the merits of the case. So all those things come into play. And that's why don't just think, oh, they've gone off, oh, it's okay, just take them off the books and forget about them. That will end in tears. We've seen it happen that way many, many times. Okay, that's all I really want to say about this morning. So we've got a little bit of time, and I haven't outstayed my welcome, as some people in government appear to be doing at the moment. But just to remind you, if I may, of a couple of things. If you want to put your questions in writing to us in email, please do. If you haven't had your question answered in the chat, then again, you can put that in writing to us by email and we'll get back to you. There's been a little poll, I think a few questions asked of you. If you'd like to just wouldn't mind entering that, that would be great. And also remember that our booking for the Law on Tour has started today. So if you want to know anything about the Law on Tour, get on our website, have a look. Everybody who comes on the Law on Tour loves it. It's a brilliant one-day kind of complete employment law update. So just have a look and see if it's for you. In the meantime, let me say thank you very much for joining this breakfast briefing on 9th one, coming up number 10. If you're happy with the briefings and you've enjoyed them, then keep your eyes peeled. We will be doing a number 10 very soon. So thank you for joining me and have a great day. Take care out there, and I'll see you on the next briefing, if not before. Thank you very much and goodbye. Bye now.